So we're not doing badly. We're making some good progress. So my task this afternoon is to, where is my slide? Slide? Okay, that's me. I need my slides. Anyway, so my task this afternoon is to set out. I was asked to rethink the framework for resolving intra-African commercial disputes. So I was asked to, thank you. So I was asked to basically look at non-state actors. So we've been here, we've had substantive, very interesting, very informative discussions on the African Free Trade Agreement, trade area agreement. Is a mouthful. But we need to be careful. So I'm just going to say something as an aside and then I would start, which is yesterday we mentioned the dispute settlement mechanism of the AFCFTA. But we do need to remember that the DSU mechanism of the Africa Free Trade Agreement mirrors that of the WTO. And so it's a state-to-state dispute resolution mechanism. So I'm going to quickly, as you've heard, I sent in a fully written paper. Because they're gentlemen, they tore my paper to bits. So they came prepared to basically critique the paper, which is very useful for me as an academic. And so Tola is going to, we've had this discussion on should a state espouse the claims of its citizen under the Africa Continental Free Trade Agreement. And so I promised him that I would give him the first shot, and so I'm going to just put it out there, and then he would, when he comes back onto this, he's going to deal with it, and then I can come back onto that. So initially, the way I set up was to talk about the barriers to intra-Africa trade in goods, services, and investments. So we already have the Africa Continental Free Trade Agreement. It's already dealt with. We have protocols in trade in goods and services. And then we have the DSU protocol. So we're going to enter into the negotiations for investment. But on the back of investment, it's important to remember that we have the Pan-African Investment Code, which is new, which was agreed under the AU platform. So the key question when we think about the protocol on investment is going to be how would you relate that with PAC, with the Pan-African Investment Code? How would they speak to each other? And so that's something for us to bear in mind. And one of the schools of thought out there is, well, basically, why don't you just reproduce PAC as the investment protocol? Would that be a wise thing to do? So that's for the future, just thinking about that. So I'm not going to go over the barriers to intra-Africa trade. We've talked about those for 2 days. So that will save us some time. The key thing to remember is that my paper and my presentation focuses on non-state actors. So I'm going to start by defining what I mean by non-state actors. So non-state actors would be, if you like, the private physical legal persons that actually perform the trade in goods and services. What it also then means is that a state entity, when dealing as a commercial or in a commercial capacity, would fall within a definition of non-state actors. The reason is just to separate the public law aspect from the private law aspect. So if you remember what I had said earlier on about the DSU, that is state to state, and so that we can actually focus on those who actually implement the trade. So that the remit of what I'm going to be talking about is, if you have a trade transaction, between, let's say, a Nigerian seller who is selling to a Mozambican buyer, okay? And the goods, whatever the goods are being carried by Ethiopian Airlines, okay? So payment is going to be made in Ghanaian cedi, or since the Africans love the US so much, the US dollars. Okay? And you have different banks financing different aspects of this trade. When you have a dispute, how are you going to resolve that dispute? Where should you be going to? Would you as the Nigerian seller, would you be happy to go to the courts in Mozambique? By the way, they do not speak English. That is the first barrier. They don't speak English. That's not the language they speak. So, would you want to go to Mozambique? The Mozambican is heard what we were told during the dinner, that the excellent lawyer needs to know the judge. Apologies, judges, I haven't said anything untoward. They've heard that. They've heard that the Nigerian judiciary, which, by the way, it is a research that was conducted by the Nigerian Bureau of Statistics and UNCTAD that said that the public services, public sector in Nigeria, so if you take the police, you take the judiciary, they are seriously corrupt. I'm just quoting, quote and unquote, not my words. And the Mozambican has heard that. Do you think that the Mozambican would want to come to the Nigerian courts? If you were the Mozambican, or even if you as a Nigerian, you've heard of what's going on in the Ghanaian judiciary, would you honestly want to go to the courts in Ghana? That, for me, is the case against cross-border litigation, to start with, within the African continent. So for me, where I sit in my office in London, I do things, and I'm thinking of, when I talk about regional integration, I'm thinking of the EU model. But the EU model is much deeper, and we have integration even on the private law end of the stick. And then, so the question then becomes, if I would not litigate because of language, different legal systems, lack of confidence in the judges, and there are various reasons. What are my other options? We haven't even added costs to that equation. What are my other options? Then I thought to myself, and I said, well, maybe I should do mediation. ADR, fantastic, great. But what is the problem? The major problem we have with mediation is enforcement of the settlement agreement. How on earth am I going to keep going back and forth to Maputo if I have a settlement agreement? How am I going to enforce this? How am I actually going to get my money? That's what I'm interested in. I want to get my money. I want this piece of paper translated or transformed into cash. How am I going to do that without incurring additional costs, with no guarantee that I'm going to end up getting my money? So I said, well, maybe for me, cross-border trade, intra-Africa, maybe mediation will not do it for me. And then stepped back. I looked at the African continent, and I said, well, with the work that I have already been doing on arbitration, let me think a little bit more creatively and see if arbitration will cut it for me. And I said, yes, I think that's the way to go. So, what is arbitration? So, arbitration, as most of us, hopefully in the room, know, I just simply say it's private litigation. That's the short form. So if you remember that in mediation, what we're trying to do is get the parties to speak to each other, to resolve the dispute. In arbitration, you're speaking to the judge, just like the chairman said. I don't think I was properly introduced. I am the chairman of this panel. Then you know he used to be an attorney general, you know. But that is what the arbitrator is. So the arbitrator is a private judge, if you like, because you're trying to convince the arbitrator, okay, of the correctness or rightness, or persuade him to go with your own side of the story. The arbitrator makes a decision for you, which is binding on the parties. I said, that is what we need. So I want to know that I have a legal document that I can actually transform into cash without having to go through the whole process again. I then looked at African countries, and we have quite a number of African countries who are members of the New York Convention, which is basically an international convention that allows you to get an award in one country, one member country, and you can enforce it in the 151, the 152, the 155 or so member states, all the other member states. That is fantastic. You have to find an asset anyway. And then I said to myself, we have 36 or thereabouts African member states of the New York Convention. So we do have some common treaty that we can all work with. So what is the bottleneck? What is it that is frustrating arbitration in Africa? And what is frustrating arbitration in Africa are the courts. So the fact that the courts, generally in arbitration lingo, would say the courts are not arbitration friendly, even though we do not define what arbitration friendly means. For me, I think that most African countries, I think that the legal systems are broken. That it's not a question of just the courts, but that the legal systems are no longer fit for purpose. They're not designed for the 21st century. And just like every other thing on the continent, we've just carried on with colonial structures. And we do need to change the colonial structures. How we're going to do that, I don't know. But we do need to seriously think about it. And so the way I reimagined the whole system is I said to myself, if we have intra-Africa trade, so remember the scenario I gave you, so a Nigerian seller, a Mozambican buyer, and all the other intermediaries in between. But let's say the primary dispute is between the seller and the buyer, the Nigerian and the Mozambican. You go to arbitration. You can go to arbitration anywhere on the continent. So let's choose a viable jurisdiction like Kigali. So we were in Kigali in May. It takes you 3 minutes. So if you're a government official in the room, if for those of you who were in the room of ease of doing business, yes, Nigeria is jumping up and down, that you climbed 24 steps. Don't forget that every other country, they're not just sitting, they're actually moving. You go to Kigali. In 1990, there was a genocide. Everything was broken. But you go to Kigali, regardless of who you are, whether you're the EU ambassador, Buhari's daughter, Oshibajo's wife, you get your visa under 3 minutes. Nobody is smiling sheepishly and foolishly at you so that you can bring anything. Nobody does that. 3 minutes, $30, you get your receipt, you're out of the place. And Kigali, as small as Kigali is, that is the center of what is going on in Africa. So you might think Nigeria is great. but you're great in your backyard. Your greatness is to yourselves. It is not to the rest of the continent. In Kigali, from the airport, you have Wi-Fi. As you step into the airport, you have Wi-Fi. There is electricity. Nobody is considering, do I have diesel in my generator? These are practical, important things that we do need to seriously think about. And it is for the government. So the government of Nigeria is letting Nigeria down. That is the simple truth. The government of Nigeria is frustrating Nigeria. I was watching the TV, permission I have 3 minutes, good. So I was watching the TV, and I saw rice being destroyed. And I stepped back, and I said, we have IDP camps. There are people who have no food. It is unconscionable for a state to publicly destroy food. And we are in an era of sustainable development. The UN, we have sustainable development goals. If you don't want to eat parboiled rice, why don't you just place a duty on it? Give me the choice. If I can afford basmati, let me buy basmati. If I can afford local rice, let me buy local rice. Why does the Nigerian government think that we are such children that they need to tell us what to eat, how to work, what to do? It must stop. This is 2018, for crying out loud. It is not good enough. Okay, so that is my 1-minute rant, which I'm always allowed to do. Anyway, back to the paper. So the point where the problem is in enforcement of awards. And I have panelists who disagree with me on this. So in my reimagining that, what I thought of 2 things, or 3 things that are new. One is, at some point in the future, we need to think of decentralizing the enforcement execution mechanisms. So the only way you can execute a judgment is using the Sheriffs and Civil Processes Act and all of that. We need to take that out of the public domain and diversify that. If you like, privatize that. So that's number one. And in the paper, I have various ways that I think we can do that. But that is really controversial, so I can park that. I've just mentioned that. I can move on. The second idea was we can get regional arbitration centers. So we did some research, and we have 71, 72 arbitration centers dotted across 39 jurisdictions over in the continent. We also did a survey of arbitration in Africa, and what we then found out was that a place like Nigeria, you have loads of arbitration practitioners, people who define themselves as arbitration lawyers. But you also have bits of the continent where there is no expertise at all. And so the question then becomes, how do we share that space? So if you have a lot in one side of the continent, how do you ensure that circulates so that we can transfer knowledge and skills? So maybe that's an agenda for Mr. Kwata and the SBL. And, the Oga of SBL is here, Mr. Tommy. George is here, so they can think about how they can disseminate that knowledge, conduct trainings, and all of that. But the idea with the regional centers is that we can then actively promote the regional centers and peg them to the RECs. So those are the regional economic commissions, the 8 of them that the AU recognizes, so that if you have a dispute regarding a particular region, you have a regional center that you can go to, where it's just a question of quality assurance. That's what we're doing with that. So that's the second reimagination. The last one, which is the most controversial reimagination, which is what is exciting my panel, which is why I left it to the last, because my chair will give me 2 minutes to speak on it, is we need an African Commercial Court. So the idea with the African Commercial Court is when you've done your arbitration, you get your award, you get a choice. So there's party autonomy. You can decide that you want to go through the Nigerian legal system and spend a generation sorting it out, or you take your award, go to the Africa Court, Commercial Court, and you can get it enforced. So that there would be the African rights, that is the final. All you need is to confirm, reascertain the stamp of the court, and then you go and execute it. So you have similar processes within the Ohoda region, and then the question then becomes, how are you going to set up the court? What are the limitations to setting up the court? And in the paper, I compared that with what goes on currently in Mauritius, where you have a dedicated court for international arbitration. Thank you very much. I'm looking forward to questions.
Thank you very much, Dr. Onyema. You can see that I'm a huge fan. I gave her 2 minutes without inducement. You see that we're stamping out corruption all over the place. Incompetence is the problem that we have in this country. Let's move on quickly. The next stage is, and I think you've taken on board her suggestions. They're very, very, very stimulating. I found it very exciting. We're going to do the panel discussion, and each of the panelists will take just under 10 minutes to pay back for Dr. Onyema's 2 minutes I'm stealing. So we're going to start with Mr. Tola Oshobi. He's a senior advocate of Nigeria. He's often acted as counsel in several international EPC contracts, and he's the head of litigation, partner and head of litigation at Babalaki & Co. Mr. Tola Oshobi. Please give him a round of applause.
Thank you, Mr. Chairman. Let me start by saying that I agree with Dr. Onyema that arbitration, as things stand, remains probably the best means of resolving international commercial disputes, and by extension, intra-African commercial disputes. But I think a serious look has to be taken to mediation. I know mediation is not necessarily popular with lawyers, but I think in the African context, a serious look has to be taken at mediation and see how we can scale it and make it effective across the continent. And my reasons are simple. I mean, the disadvantages of arbitration are well known. Let me start by also pointing out that mediation will never replace arbitration. So it's not intended as an alternative to arbitration or even litigation for that matter, but as complementary to both. And the disadvantages of arbitration have been noted. I mean, we all know them: costs and the length of time it takes. This is also applicable to litigation. These disadvantages are magnified in Africa, as Dr. Onyema's paper points out. This precisely because most of intra-African trade taking place now, and it's quite significant, is being conducted by micro, small, and medium-scale enterprises, and who invariably operate in the informal sector. This means that most of their transactions are not documented. This necessarily implies that they don't have arbitration clauses. Even where it is documented, they don't have arbitration clauses most of the time. And the paper points out that as well that post-dispute arbitration agreements are rare anywhere. And so that is also not an alternative. So the question is, with these disadvantages, what then is the option? The option that exists, of course, is to go to the national courts, which Dr. Onyema also deprecation is the wrong word, but it's not feasible in many instances. For one, we don't have reciprocal enforcement of judgments framework within Africa. And I don't recommend one. I don't think Africa is matured enough to have an intra-Africa judgment enforcement framework. We don't have sufficient confidence in our legal systems. And obviously, she mentioned the suspicions and lack of confidence one African would have in the court system in another African country. Again, all the shortfalls or pitfalls of arbitration, the delays, the costs, and all that are also applicable to litigation. So I think for this reason, a stronger consideration should be given to mediation from a policy standpoint. As I said, I don't think lawyers are very excited about mediation. It's not as fancy or as cool as arbitration. Of course, you don't make as much money, but I think I'll plead with you to hear me out on this. Now, as I said, mediation is not a replacement for arbitration or litigation, but let me give a little bit of some statistics. And it's difficult to get statistics in Nigeria at the best of time, where they exist at all. But according to the Lagos Multi-Door Court House, they have an average of over 1,000 cases every year. And 40% of these cases are successfully settled by mediation. Now, for instance, in 2017, 1,397 cases were referred to the Lagos Multi-Door Court House by the courts, and 357 cases by walk-in, the parties walked in, so you have that facility to walk in the Lagos Multi-Door Court House. 475 of the cases referred from the courts were settled, and the settlements were entered as judgments of the court. 235 out of 357 of the walk-in cases were settled as well. Now, I was able to get some statistics from the NJC as well. Out of 55 judges in the High Court of Lagos State in 2017, 1,851 judgments were delivered in contested cases. 5,235 were in uncontested cases. I need to make a clarification here. As I said, the statistics are not very good, but the uncontested cases would include judgments obtained in default of appearance or judgments, cases where the action is dismissed, I imagine, for want of diligent prosecution. But most of the judgments were actually from negotiated settlements that were entered as judgment of the court, or from mediation that were entered as judgment of the court. So we have 500, so let's even say it's half of that number. That's over 2,500 cases settled by negotiation or mediation against 1,851. Invariably, the matters settled by mediation are concluded much more quickly than the cases that go to court. Now, I was constrained to rely on statistics from outside the country, and I will share that also. According to studies commissioned by the Financial Industry Regulatory Authority in the United States, due to the delays and cost of conducting litigation or arbitration, only a small fraction of cases, even in the US, which presumably has a more efficient and strong administration of justice system than we do, only a small percentage of them get concluded. Only a small percentage of them go to trial. The overwhelming majority are either withdrawn, dismissed, or settled. And in the first 6 months of 2011, only 21% of arbitrations were concluded. 79% of them were resolved by negotiation and mediation. There are no reliable statistics as to the numbers that were done by mediation as against negotiations, but they were resolved by either of those two processes. 85% of the cases that were mediated under the FINRA, that's the Financial Industry Regulatory Authorities program, were settled. 85% reached successful settlement. The American Arbitrators Association, also agrees with this. So I guess I've been told I need to round up, but I'll round up very quickly. I still have a lot to say. But the simple thing, my simple conclusion is this: if Lagos State has a framework for enforcing mediation settlements, I see no reason why, if we must create an African framework for settlement of this, because the principal disincentive to mediation is that we do not have a definitive self-enforcing framework. And that can be accomplished by treaty. There's no reason why a mediation by recognized mediation body, either affiliated to the courts or one of the regional arbitration centers, cannot be entered as judgment in the court at the jurisdiction where the mediation was conducted, or in any of the other courts within the African Union. Because what you are registering is not a court judgment that you don't have confidence in, because you don't trust the legal system in the other country, but something you actually agreed to. So there's no reason why it should not be registrable across the continent and enforceable across the continent. That's my contribution. Thank you very much.
Thank you very much, Mr. Oshobi. The mothers around here would recognize what I did when I told him, I didn't say a word, I just gave him the eye. And he knew his time was up. Yeah, my mother used to do that. Now, the next panel discussion is senior counsel, senior lawyer, Digi Omotosho. He has frequently given expert evidence in several international litigation abroad. He is the senior partner in CLP Legal. Please welcome Digi Omotosho. Thank you.
Good afternoon, ladies and gentlemen, and thank you very much for this opportunity. Chairman, thanks very much for my 10 minutes. And Ms. Onyema, thank you very much for a really wonderful paper. I have a couple of observations, really, and those relate to practicality. Let me start by nailing my colors to the mast and telling you that I'm for litigation. That may sound controversial, but as I go on, you'll see why. I'm in agreement with Ms. Onyema when she says, and I think most of us agree, that in a perfect world, arbitration would probably be the most or the ideal mode of dispute resolution across borders. But the reality on the ground, as I think Mr. Oshobi touched upon, is that very often the international disputes that arise are those which arise out of the informal sector and also arise out of businesses being done by SMEs. And because of this, they tend not to contain the sophisticated arbitration clauses that will allow for the consent that is necessary for arbitration. That therefore leaves us with a substantial amount of cross-border disputes that we cannot take to arbitration simply because there is no consent for the arbitration. And turning to mediation, the same problem is likely to arise because, again, consent is required for mediation, even though in the case of mediation, it is post-dispute rather than pre-dispute in arbitration. So if that consent is absent, you really are left with litigation. The question then would be, how can we make litigation a more attractive tool for resolving these sort of cross-border disputes? And those of us who've been in practice will recognize that there are probably two areas with regard to litigation that are problematic in ensuring that you have an effective dispute resolution. I say those two because those are perhaps the most obvious ones. The particular jurisdictions and the difficulties faced by the courts and the time lag and time wasting, I think are realities which we will need to deal with in a more holistic way. But if you are going to have effective litigation, two things must be present. You must be able to bring the errant party, as it were, before the court. You must be able to serve him effectively. And the second is that you must be able to enforce whatever judgment you are able to obtain against this person. Now, those two aspects tend to be related, and this is why. Invariably, if there is no enforcement protocol, international enforcement protocol, you are left only with the common law. And in effecting a judgment in a jurisdiction different from the one in which it is obtained, you will usually find that the common law provisions insist that the party has been brought before the court in a legitimate manner. Now, different jurisdictions have different rules as to service. If you are going to be able to effectively relate the two together, that is the enforcement and the bringing the party before the court, there will need to be an international protocol for the enforcement of the judgment and for the service of the processes. So my suggestion would be that there would need to be a treaty-based international protocol across Africa that would take into account both the bringing of the party before the court, bringing him under the jurisdiction of the court, and enforcing the judgment when you eventually get it. Fortunately, the way the development of business has been going in Africa with the African Continental Free Trade Agreement, which Mr. Shoshere has pointed out, Nigeria has not yet signed up to, is a platform on which this sort of arrangement can be built. There is no gainsaying the fact that the courts will continue to be a problem, and the fact that there are different jurisdictions and different attitudes to litigation. But ultimately, at the end of the day, in situations where there is no choice other than to litigate the matter with the best will in the world, the attraction of mediation or arbitration, on the other hand, just appear to be a fleeting mirage that we may not be able to attain. So my suggestion would be that we need realistically to look at ways of making litigation more effective across borders, and in doing so, we need to look at manner in which we can effect the enforcement of the judgment and bring the parties before the court, even when they don't want to come. The reality on the ground is that if a party in Nigeria is being owed by one in Kigali, and the man in Kigali is not ready to come to Nigeria, and the man in Nigeria is not ready to go to Kigali, nothing's going to happen. You will find that the best advice you can give is see whether you can get a lawyer in Kigali who can do this case for you, get judgment for you in Kigali. But the real problem there is you don't have any power, you don't have any control, and you really are not familiar with the system in that country. You would want to be able to litigate in your own jurisdiction if the conflict of laws issues will permit you to do so, and then be able to enforce the judgment you get in several other jurisdictions. That would be my contribution.
Thank you. Thank you very much, Mr. Motosho. I didn't even have to give you a look. Thank you. So the suggestions are coming out, and the divides are becoming clearer, and we're seeing the contrast. And I think we'll take it to Jeff Folkoff now. Jeff is, Greg. Forgive me. I used to know Jeff Folkoff, that's why. Greg Folkoff. He's a partner in International Litigation and Arbitration Group of Evershed Sutherland. His area is commercial and international investment arbitration, and he has considerable experience in Africa. So, Greg. Maybe if we clap, it'll work. We forgot to clap.
Thank you, Mr. Chairman.
There you go.
Thank you, Mr. Chairman. I think the advantage of sitting on this side of the stage is that I can't see him when he tries to give me difficult looks. So, with your leave, Mr. Chairman, I'd like to start. I'm starting from the premise that I accept what Dr. Onyema has said, which is that arbitration is a successful way to help to lubricate the wheels of international trade. With that in mind, I have 3 points to make. The first is the approach of international businesses to cross-border arbitration within Africa. The second point is 2 elements necessary for the success of African arbitration, in my view. And the third point is opportunities available and where we find ourselves today. So turning to my first point, the approach of international businesses to African arbitration. And I speak here from a personal view of somebody who represents international companies who have African operations, who have African businesses, who have African branches, African subsidiaries, African directors. My clients, the big international businesses, they know Africa. They are the clients, they are the companies that you see, the international brands that everyone in this room will be familiar with. You all know that they have local operations. They know the markets they operate in. In advance of coming to this conference, I spoke to a lot of my clients, a lot of the lawyers in the legal teams, in the head office legal teams, and also in the local legal teams within the local country and the local branches. And it's not a scientific survey. I'm certainly not a scientist, I'm a lawyer, but it is a representative survey, and I think what this shows is that it's representative of the general view of international business. And that general view is that there is a disconnect between national arbitration and international arbitration. What all of the clients that I've spoken to have said is that for their African businesses, they are very happy for their Nigerian subsidiary to enter into a contract with another Nigerian company with a contract that is governed by arbitration in Nigeria. The same in South Africa with another local South African company, the same in Kenya, the same in Uganda, etc., etc. But all of those international businesses invariably have said that they will not accept their local African subsidiary entering into an international arbitration in relation to a transaction outside of the country where their own subsidiary is based. So they will not have arbitration, for example, in the way that Dr. Emilio Nyema has suggested it, between a Nigerian buyer and Mozambican seller. In a situation like that, my clients have laid down rules within their organizations that that type of arbitration cannot be within Africa, it cannot be within a neutral African jurisdiction, it cannot be in South Africa, my country, it cannot be in Rwanda. In that situation, those arbitrations have to be seated in the well-known global arbitration hubs, whether that's in Singapore, whether that's in Dubai, whether that's in London. And that, I think, is a critical issue that we haven't faced, is that there's two different perspectives here to arbitration. The question is, why is that the case? It's fairly obvious, in my view, why local parties will accept local arbitration in the countries that they're operating in, because they know the courts, they know the systems, they know the arbitrators, they know the arbitration institutes, they know how it works. Similarly, they don't know how it works when they are contracting from Nigeria to Mozambique, choosing South African arbitration. I can be fairly sure that there are very few people in this room, Nigerian lawyers, who would know how South African arbitration would work. I'm sure there are some who do, and the reason that there are some who do is because South Africa is starting to make a push to increase its profile as an international arbitration venue. Mauritius is doing the same, as we've heard. Rwanda is doing the same, as we've heard. But in my view, that's not enough. It isn't enough because it hasn't yet gotten to the point where it's changing the perception of local lawyers who don't yet understand that it's okay to go to South Africa for arbitration when you're contracting between Nigeria and Mozambique. So one of the issues I face is that it is very much a perception issue. But at the same time, the only way to resolve that perception issue is to create an arbitration regime that is as good enough as what one would get if they were going to London or to Paris or to Singapore. And that brings me to my second point, which is the two elements that are necessary for the type of arbitration that we need in order to promote cross-border arbitration in Africa. So my second point, these two elements. The first element is what Dr. Onyema has already mentioned, which is the latter element, which is enforcement. Without a recognizable and sophisticated method of enforcement, there's no point in going to arbitration, and we all know that. The first element is the local court system. And the local court system is not only in the country of the buyer, the country of the seller, it's all of the countries around. And the reason for this, I say, is that it is extremely necessary to have local courts that can have a suitable arbitration procedure, that can demonstrate a hands-off approach to arbitration, a non-interventionist approach, local courts that have educated and commercial judges, and also, I think critically, local courts in the situation that's been described as the Nigerian... I shouldn't have looked. Okay, noted, thank you. So So I'm moving finally to my third point, and this is my final point, which is the opportunities we have. And I see the existence of the free trade agreement as an opportunity to discuss these issues at an interstate level, at international cooperation for raising the bar across the continent for a court's approach to arbitration, for finding some form of agreement between states as to how courts will treat arbitration, how courts will treat jurisdiction, raising the bar at an international level to educate judges, to promote talent in the courts, to enable a regime where people have confidence in each country that they can use arbitration in another country. And the point I would like you to take away with is that I see the free trade agreement as the opportunity to start that sort of discussion at a state level. It's certainly good enough to have that discussion amongst us here, but I think we need to go one step further than that. Thank you.
Thank you very much, Greg. Thank you. The next intervention will be from Ben Cisse, who is with the Africa Finance Corporation, the EFC, and he'll certainly give us a continental flavor to his contributions. Thank you. You don't have 10 minutes, though.
Thank you very much. Good afternoon, everyone. My name, as you said, is Ben Cisse. I'm an Associate Vice President at Africa Finance Corporation, and I'm originally from Côte d'Ivoire. I would like to thank you for the opportunity to speak here in my own name, but also on behalf of Dr. Adesegun Akinolubade, Executive Director and General Counsel of the African Finance Corporation, and also Ms. Eshen Nana, who is the Director of Africa Finance Corporation. So I would like to take a mixed approach here. We as an institution, for those of you who don't know what Africa Finance Corporation is, we are a development finance institution which was established to improve African economies by proactively developing, financing, and managing infrastructure, industrial, and financial assets. So we almost have a preference in respect to agreement to which we're a party for arbitration for a very simple reason. Given our GFS status, we want to make sure that the exemptions, the privileges, and the immunities that we get as a GFI are always preserved. And we can only ensure that this will be the case with arbitration, because we don't know whether any legal system of any country will allow for us to have this kind of guarantee. And as you know, as lawyers, when you are involved in a court, in a dispute before a court, there are so many things that can happen before a judge makes a final determination of the substantive matter of the case, including ordering any interim measures. We can allow for a party to take interim measures. So we, on that basis, usually do not have a preference for anything else than arbitration. But maybe that's not the reason why I'm actually taking this approach. I would like to take this approach based on my own experience, and also, which is based on my experience in private practice. We have, in 17 member countries, which we have an organization which is the Organization for the Emulation of Business Law, which is most commonly known as the OHADA. OHADA is a set of regulation, rules, and implementing institution which was established under the auspices of the Organization for the Harmonization of Business Law. And under OHADA law, which is something that maybe most people here don't know much about, but I'll say a bit about it, you have two different ways of resolving an issue by way of arbitration. There is an OHADA law on arbitration, which basically is a tool that is given to OHADA, to people who actually want to submit the dispute to the OHADA to resolve the dispute under the OHADA Act on arbitration, as long as one of the contracting parties is domiciled in one of the OHADA member countries, or the contract is to be implemented partly or wholly in the OHADA member country. That tool is available. But the issue with the OADA Arbitration Act is that it does not allow for you to use your arbitral award and enforce it in any country other than an OADA member country. And even in the case you want to use your arbitral award for enforcement purposes in one of the OADA member countries, you can only do so under the laws which apply in that particular jurisdiction. So that creates some kind of uncertainty as to whether you will be able to efficiently and in a cost and timely way enforce your arbitral award. But there is something that OADA has done, which is actually something that I haven't seen anywhere else, which is arbitration that can be conducted under the Common Court of Justice and arbitration rules. So basically, the Common Court of Justice and arbitration is an arbitration center. It's actually the most important one under the OADA, in the OADA region. And thank you very much. I got it away. Thank you.
You can finish that sentence. I will let you do that.
The reason, I will just say a bit of, something about the mediation. I was just going to say that I want to take a mixed approach, which is both based on the fact that I believe that arbitration, or at least in a particular regional economic area, there is something that has already been established, which is the OADA arbitration framework. I believe it's already working. I believe we can actually think more about it to see how we can improve it. But I also would like to take a mediation approach. I understand that in most countries, when you have a decision that is made after a mediation procedure, the decision that is made is actually not binding on the parties. But OADA has also improved that, because when you have a decision that is made after a mediation procedure, you can actually have it homologated or endorsed by a court. And that decision is something that you can use for enforcement purposes, not only in the country where the mediation was seated, but also in any other countries which are members of the country, of the OADA organization.
Thank you, Ben. Thank you. Thank you. Thank you. I'm sure that will get a lot of interest from the public about the working of OADA. The last and certainly not the least is Mr. Tola Onoyemi, who is an expert in international law, trade law, technology and investment law. He is the head trade remedies and assistant chief negotiator at the Nigerian Office of Trade Negotiations. And I'm sure he's going to tell us why we didn't sign Act 5 at the end of the day. Please welcome Mr. Tola Onoyemi. You don't have 10 minutes.
Thank you, Mr. Chairman. And thank you, Dr. Amelia, for your presentation. The good advantage of going last is that you get to see everyone's mistakes and you get to prophesy. All right, so I have 3 points. The first point is the defects of what Dr. Amelia proposes. And I think everyone has reiterated it a number of times. One is the practicality of implementation, particularly enforcement. One of the important things about any court system that would work is that you must have a system for ensuring that you can bring the parties before the court, but more important, that you can enforce whatever awards you come up with. And another interesting thing when you look at the entire Brexit conversation is that countries are beginning to push against a system in which a supranational body starts to push down what it thinks is rules. So I can imagine a dispute of the sort she said, and I go straight to the ACC at some point or whatever, and you're asking a court system to enforce what the ACC has proclaimed. Or an extra case in which, even if I go to the ACC and I get an enforcement of award, I go to, say, a domestic court, and the court says, why am I enforcing this? So there are those dynamics. 2, which is my second point, is that any system for resolving intra-African commercial disputes that will work has to be a marriage of 2 things: prevention mechanisms and resolution mechanisms. Now, prevention mechanisms, like some of the things they said in OADA, which are issues like harmonization of standards, issues like enforcing the good trade remedies system, standards, there's a number of those kind of things. And that is a big part of what has to be built into the system before you even get to the point of actually litigating or in any of those nuances. Now, the interesting part is what I think is probably a more workable structure. And it's based on separating what are principles of laws and principles of facts. Now, what I mean is this. There is the very popular rule of diplomatic protection in international law, which means that a state party can represent its citizens before an international tribunal. Now, what happens a number of times is the CFTA sets up a DSU mechanism, which is very much similar to what the World Trade Organization DSU mechanism looks like. What is a best play is that when it's a principal issue, so basically trying to resolve whether this principle makes sense or not, that the country as a state party adduces it before the CFTA DSU and trashes out the principle. When the principles are clarified, a domestic court can apply that in several instances replicable. That's a system that works as against the case in which an ACC, which is removed from the CFTA DSU system, has to resolve issues of principle. Now, if it's an issue of fact, of course, there's several methods that exist. There's a domestic court, there is the remedial method, whether arbitration or mediation. And more interestingly is that if you then tie all these together, what happens is this, is that I, as a party, can choose, if it's an issue of law, to get my state party to represent me before the DSU and resolve the principle. If it's an issue of fact, I either end up in a domestic court trashing out the issue, or I end up in an arbitration or mediation mechanism. And once that is sorted out, I can immediately go back to the normal system that exists. And then you talk of the new issues of the New York Convention and issues of enforcement protocol, which are, in fact, a more interesting issue. Now, if all that exists and all that is put in place, then the question is, what exactly would the ACC be doing? And that exactly is a framework that I think is feasible. What you'll find a number of times is that in long-term systems, it's always best to build on the back of what exists and then expand it. So issues of a framework enforcement, which is a bigger issue. Issues like what he said about ensuring that there is a lot more harmonization between all the state parties that exist. That is a more interesting system of getting the system or commercial arbitration to resolve itself than a system in which I'm going to an entirely new body like the ACC. That's just my thoughts for now.
Right. Right, there you have it. I know we have questions from the floor. Do we have any questions? You had been encouraged to put your questions into writing. We will deal with written questions only because of the length of time it takes some of us to introduce their family lineage before they finally ask the question. But really importantly, there you have it. The ingenuity of the idea behind a supranational court dealing with issues of enforcement, the whole purpose of the enterprise of dispute resolution in the first place, getting a remedy. And then you have the suggestions of strengthening the systems within the countries to ensure that the disparity and the choices disappear when everybody has strengthened their system. And the OHADA example, and as well as the example of what the WTO is already doing by way of practicalizing the solutions. And you know, the preference for litigation and the choice of a treaty-based solution to making litigation more effective. After all, if litigation is effective, it will play its own role in the whole reason why we're having conversations surrounding the best way to resolve disputes is because the public dispute resolution system has failed generally. And Mr. Shobi's suggestion about mediation. So there you have. If we have questions, we can quickly take them. I can read them, or a coordinator can read them, direct them to one of the panelists or the lead speaker, put your name and the organization you represent, and we can make this thing quick and interactive. Do we have any takers? If not, we will have, while we're gathering it, we'll allow Dr. Oyema to fire him back.
Thank you very much, Mr. Chair. Tola, the point you make, I take. But if we think of what is going on within the OHADA region, so the CCJA would make that decision because, of course, the Supreme Courts within the OHADA region are basically not part of the Uniform Act system. But what the CCJA does is that the CCJA does not have execution powers. So they do exactly what the ACC, what the proposal is. So that the CCJA basically enforces or makes a decision. You have to go back to the national member state court for them to enforce effectively, to execute. And so we already have a system that does that works on the continent. So why do you not think that we can replicate that either on a regional basis or continentally? Yeah. East African court, they do that as well.
Yeah. Well, thank you. No comeback here. Maybe I have one question for Greg. You mentioned the strengthening of the systems within the countries to bring them all up to an even standard that is performing. Could you give us one practical way in which you could encourage, say, a flagging state. I don't want to name any states. You might be sitting in one.
I think perhaps a particular example is to go back to the example that Emilia has used about the Nigerian buyer, the Mozambican seller. In that situation, as you suggested, Emilia, they would have chosen, I think it was the South African arbitration that you'd suggested. In that situation, if the Nigerian buyer or the Mozambican seller had an issue, they would have to take that issue to arbitration. The only court that has jurisdiction over that arbitration is the South African court. The Nigerian court has no jurisdiction over anything to do with that relationship. The Mozambican court has no jurisdiction to do with anything of that relationship because the parties have chosen to contract out of their court's jurisdictions in order to go to South Africa for the jurisdiction of the arbitral proceedings. And it's this, Mr. Chairman, that I feel is the difficulty, that as I understand it at present, maybe Nigeria is the wrong example, but in this situation, the courts of the home states of the two parties are willing to interfere when the parties have chosen arbitration in order specifically to avoid that interference.
Yeah.
That is the particular point.
Exactly.
Thank you. Thank you. I must really let the floor. You can do it, yes?
We have 3 questions so far. The first is from Niyi Emmanuel of Stonewall and Scones, and that's to Tola Onayemi. And he says, distinction between the principles of law and issues of fact and taking them before different courts seems unclear practically. Which would come first? The next question doesn't have a name to it. The dominance of English law and English firms in cross-border transactions is based on predictability, reliability, commercial sensitivity, etc. of the English legal system. Should we not be investing in developing and improving Nigerian legal system to create legal certainty and confidence in our courts, etc., in the hope that users across regional borders may find the system attractive someday? It doesn't specify panelists, and it doesn't have a name on it. And there's the last one. And there's the last one.
Somebody, don't worry.
And this one is from Chisom Chude, and again, it doesn't specify who to answer. The increasing number of investment disputes involving African states can be attributed to a number of factors. There is an inevitable activity anywhere and increased investment-related disputes. My question is, why don't we consider a multi-step process that uses 2 or more of the agile mechanism? So we've got 2 questions. One is directed to...
Not for those 2
no owner for the...
Yeah, okay.
For the long
Dr.
run.
Onyema will take the second one about multi-step dispute resolution. Do you want to hear it again? Colin, can I...
I think I can remember. Do you want
Okay.
to take it now?
Yes, you can take it down. And Mr. Shobi will take the question about investing in the Nigerian legal system.
I think for the question on the multi-step dispute resolution process, that is the way to go. Again, party autonomy, it depends on what the parties themselves want. And part of what the problem is with the current investment backlash, as they call it, against international investment arbitration, and where we blame the arbitrators and conflicts and double-hatting and all of that, the important point is it depends on what is contained in the BIT. So if you look at the Morocco-Nigeria BIT, it has a stepped dispute resolution process clause. They have all sorts of things, including a committee that you can refer to. That is a good example. That is a modern example. So I suppose the summary of the answer is, yes, we can do that. But don't forget that ultimately, once a dispute arises, parties are not as reasonable as they were when they were entering into the contract. And then once you get the lawyers, as this room is full of you, once you get the lawyers involved, it becomes even more acrimonious. So you want to be sure that you protect your client upfront when everybody is still popping the champagne and they're happy.
Thank you. Mr. Shobi.
I'll just read out the question so that we put it into perspective. The dominance of English law and English law firms in cross-border transactions is based on the predictability, reliability, commercial sensitivity, etc. of English legal systems. Should we not be investing in developing and improving the Nigerian legal system to create legal certainty, confidence in our courts, etc., in the hope that users, even across regional borders, may find the system attractive someday? I mean, I don't know if this is a question or a comment, but I think the question itself suggests the answer. I mean, it goes without saying that naturally. And I think the English system, even as strong as it is, every day they are trying to improve it and make it better, stronger, more effective. So it goes without saying that we should, of course, invest in developing and improving our legal system for our benefit, and hopefully if we're able to develop such a standard that others in other parts of the continent have confidence enough to adopt Nigerian law and as a Nigerian law and jurisdiction for the resolution of their dispute, then that will be a very good objective for us to pursue. So I completely agree with the question. I think it's more of a comment. I mean, I think the question suggests the answer. It goes without saying. I completely
Thank you very much.
Mr. Chairman, sorry, Mr. Chairman, can I add a point to that? Very briefly, is that English law and England as a seat of jurisdiction are two very separate things. That you can have English law and it can be dealt with in any jurisdiction, anywhere in the world, and you can have English seat of arbitration, which can deal with Nigerian law. And I think it is important to keep those two separate.
Yes, that's a very useful clarification. I think we only have one thing left, and that's the question on facts and law. If you can quickly do that so that we can yield for the next session.
Thank you very much. I think the best way to explain it is this, using the same example Dr. Amelia gave. So imagine an instance in which it was mahogany from Nigeria made into sculptures and sent down to Mozambique, and Mozambique refuses on the ground that it's an environmental issue for them, and they're turning it back, right? The truth is, it makes sense in those cases to set out the principles, because there's issues of psychosanitary measures, there's issues of environmental law, right? Environmental standards in trade. It makes sense for the two state parties to trash that out before the CFTA DSU and trash out principles. Because the problem with taking such issues to arbitration severally is that several arbitration panels will take different positions to it, and there's no set clearing out of what the law should be on those kind of issues. So on issues of such principles of trade and important issues, it's important to first set them out in principles wise between the state parties and set out what the principles should be, and then at that point arbitrators can then start to deal with mediation can start to deal with the nitty-gritty details when it applies itself in several other instances. That's kind of thing I'm trying to say between principles of law, which is a principle of how the CFTA works for trade and goods and services, as against clear instances of just applying what the rule already says. Thank you.
Well, with that, you will agree with me that our subject could have been a conference in its own right. But I would like to thank the panel for dealing with it in a way that I think it deserved to be dealt with. I thank you, the audience, and on their behalf, thank you for your patience and your attention. I'll yield to the coordinator. Please, thank you very much.
Once again, we would like to say a very big thank you to the chairman, speaker, and members of the panel. And again, we say a big thank you to the sponsors of this session, African Finance Corporation, Nigeria Alliance & Co. We'd like to call on the learned SAN, once again, Mr. Ayodele Akitunde SAN, to do the honors of presentation of this to the panel. So I think we'll start from the extreme end. Greg. Ben. Tola. Dr. Emilia. Mr. Motosha. Mr. Tola Oshobi, SAN. And finally, our chairman, Mr. Olashukbo Shashori, SAN. Thank you very much. Just before we take the group photographs, the next session holds here. It's the debate session, so please remain seated.
Yeah. Two. Yeah, two. Yeah. Two. Yeah, two. Yeah. Yeah. Two. One. Yeah. So. Yes. Sure, check. Check. Two. Yes. Two. Two. Two.
He said once the time is up, once he says time and he does this, shut down the mic of the person speaking. You shut down. to know the mic we will pick well without cut. This mic is just they do what they like. Huh? This that place.
Yeah.
And this one they mess up. This guy. Use some. Hold on.
Yeah. 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 Yeah.
The debate consists of very topical issues that are going to be debated upon by well-thought-out panelists. Permit me again to call them up to the stage. May I call upon Mr. Kalu Abosi, Managing Partner, Astor Law Firm.